Lord Phillips, then the President of the Supreme Court, ruling in favour of the banks. 7 banks in the Nationwide Building Society had gone to the Supreme Court to try and stop the Office of Fair Trading investigating the fairness of their charges for unauthorised overdrafts, and they have won that appeal, overturning a decision by the High Court and the Court of Appeal. So the banks have won at the Supreme Court today. What's this going to mean? Let's speak now to lawyer Daniel Barnett, who can talk us through the legal implications of that ruling. What happens now, Mr. Barnett?
Well, it's an absolutely shocking judgment for the Office of Fair Trading and for the many tens of thousands of consumers who've been relying on the House of Lords, or the Supreme Court as it's called now, to say that bank charges for unauthorised overdrafts are potentially illegal. What the Supreme Court has done is cut that attempt to limit bank charges short, and banks are now free to charge, with one exception, as much as they want for unauthorised overdraft charges.
And what happens to those cases, some million cases that have been frozen while these proceedings have been going on? What happens to those bank customers who've got cases frozen at the moment?
It depends on how those bank customers have brought those cases. There are 2 ways of bringing a case against the bank challenging charges. The first is relying on the Office of Fair Trading challenge, saying that the overdraft charges are unreasonable and unfair. Anyone who was relying on that and who was piggybacking on the back of this Supreme Court litigation has now had the carpet pulled from under their feet, and they're going to have their claims dismissed. Possibly in the larger value cases, they're going to have to pay some of the bank's costs. The other means of attacking the bank's charges, which hasn't yet been closed down and in fact is considered by many to be a fairly decent argument, is not what today's case was about, but is arguing that the bank charges amount to what's called a penalty, which is saying that they don't reflect a fair pre-estimate of the loss that a bank will incur when a client breaches its contract with a bank. The way the argument goes is that the clients, the consumers, say, I had a contract with the bank that I can go into overdraft to up to, say, £1,000, but I went over that to £1,500, and the bank has slapped a £35 charge on me for exceeding an agreed overdraft limit. The argument goes that that £35 charge, or whatever it may be from the different banks, is a penalty because it doesn't accurately reflect the value of the cost to the bank of allowing or considering whether someone should be allowed to exceed their overdraft limit. But what it means is that every single consumer now is going to have to bring an individual case against the banks. They cannot rely on the Office of Fair Trading succeeding in this mass litigation on their behalf.
I think, talking about the actual cost, the campaigners say that it actually cost the banks somewhere in the region of £2.50 for them to go over their authorised overdraft facility, that charge of £35. Those who've got claims going through the courts, those who are hoping that they might be able to recoup some money from this, will be very disappointed, won't they, Mr. Barnett? But on the other hand, we've been having a lot of emails from bank customers who say, actually, I bank very responsibly. I've never gone over my overdraft limit. And if this, the OFT, if the Supreme Court had ruled in favour of the OFT, then the banks were saying, well, actually, we'll have to start charging for bank accounts. So there will be some who'll be relieved by this decision, won't there?
Yeah, it's a very good point. The banks have to make their profit somehow, otherwise there's no point in them carrying on their normal activities. And if they can't make their profits in part through overdraft charges and similar charges, they're going to have to start introducing, as we've heard, charges for ordinary consumers to engage in current account banking.
And we heard Lord Phillips there summing up their decision. Can you just remind us the grounds on which they said they'd made that decision? Yes.
They were overturning the decision of 4 previous judges, the High Court judge and then 3 judges in the Court of Appeal. And those judges had said that the Office of Fair Trading was allowed to investigate the fairness of overdraft charges because it was a stand-determined condition and wasn't anything to do with the adequacy, this is the legal phrase, the adequacy of the price or remuneration as against the goods or the services supplied. Putting that into English, the OFT is only allowed to challenge terms if it's got nothing to do with the value of the goods or services received, the price paid for them. The Court of Appeal said, well, bank charges aren't part of the goods or services received and the bank charge isn't anything to do with the price. The House of Lords, the Supreme Court, has disagreed and said that the overdraft charges are so tied up with the remuneration that banks charge for their services that you can't strip them out, and therefore the Office of Fair Trading is not allowed to investigate the fairness of those fees.
Daniel Barnett, stay with us. I'm just going to bring in our business correspondent, Joel Hills, who was listening to that decision at the Supreme Court. Joel, Daniel Barnett saying this was a shock decision by the Supreme Court.
Yeah, I think it was unexpected, in as much as the case had already gone to the High Court and the banks had lost there and they'd lost